Let's move on to this now, because the lack of evidence to prove allegations of political interference by former President Thabo Mbeki and former Minister Brigitte Mabandla in the prosecution of apartheid-era cases took center stage in the Gauteng High Court in Pretoria today. Mbeki and Mabandla have filed an application to become intervening parties in the lawsuit that was brought by the survivors and relatives of those who went missing, were kidnapped or killed during the repressive regime against the president and the government. Now, the families and Foundation for Human Rights are seeking over 160 million rand for the alleged deliberate political decision to suppress cases referred to the National Prosecuting Authority by the Truth and Reconciliation Commission in the 1990s. Senior politics reporter Ziyanda Ngcobo is on this story and joins us live for more now. Ziyanda, won't you just help us recap today's proceedings as well, because a lot had actually been put forward.
Well, Arabile, today, and by and large, saw Mbeki and Mabandla arguing that this case regarding the lawsuit brought by the families cannot go ahead without them having their say. They argue that a lot of what has been put forward to the courts as facts are in fact, in dispute. In particular, the reliance on books and affidavits and testimonies, such as the one from Vusi Pikoli, is in contention. You remember that the former National Director of Public Prosecutions submitted an affidavit claiming that he had consistently been put under pressure by ministers and members of the executive, including Brigitte Mabandla, to drop the TRC cases. There's also a claim by the Foundation of Human Rights that Mbeki personally had made an agreement with former apartheid generals of the SADF in order to give some kind of collective amnesty, and that he did so in a clandestine kind of way. And also there's claims that have been made by the families that in his April 2003 speech, he had actually crafted a way to circumvent the prosecutorial processes by not actually also implementing and forging ahead with that amnesty task team that fell within the Justice Department. Now, this Mabandla and Mbeki say are simply not true. There's no evidence to prove that there was political interference. And if there was, then why did Vusi Pikoli or prosecutors at the National Prosecuting Authority accede to what would be an unlawful instruction? And so that is the basis upon which today's hearings were founded, and judgment has been reserved. We expect the ruling to be handed down by the weekend, but a lot of pushing from Judge Anthony Miller to ask about, the recourse that is being sought by Mbeki and Mabandla, because the Foundation for Human Rights was arguing that, well, if Mbeki and Mabandla claim that these allegations will defame them, why don't they go the civil route and sue or file a suit of defamation of character? And which Judge Miller was questioning, well, this is a different context. This case is about an alleged conspiracy to suppress apartheid-era cases that were referred by the Truth and Reconciliation Commission. So the allegations and their nature are not small, and so they would need a different kind of recourse. But the response was, well, there is a commission of inquiry that the president has set up, and you can't have a free-for-all where you have all those who are likely to be implicated wanting to be an intervening party in the court matter.
Yeah, so question marks still arise then as to whether they will get that. But as you said then, Ziyanda, then we're hoping to get more on this and a judgment on it then by weekend, as you say then. So we'll certainly see how things fare. Thank you for giving us an update on this one then, and we'll hopefully get more on this, of course, as it continues.